The court calls North Carolina Farm Bureau Mutual Insurance Company versus Martin. We welcome Mr. Bright and Mr. Brock and Mr. Flint here today for these historic virtual arguments as the court commemorates its 200th anniversary this year. Mr. Bright.
Thank you. My name is Jeffrey Bright and I represent the appellant. I would like to try to reserve 10 minutes for my rebuttal, but I'll keep my eye on the clock as well.
You may. Thank you.
This is an insurance case, and the only question I believe for this court is the definition of residents of the same household. This is a family farm. Grandmother owned this farm for 39 years. There are 2 homes on that farm. Her son has lived on the property since they purchased it. He got married, his wife moved on to the family farm. They had a daughter, she lives on the family farm. And they have all lived on their farm, at least the granddaughter, all of her entire life. The grandmother owned this farm with her husband, who's deceased, and the son, the daughter-in-law, and the granddaughter received any and all of the money that they made. All of their income came from the grandmother or the grandmother's farm. In every respect, this family farm was a substantially integrated family relationship. Only family members lived on the farm. Only family members worked on the farm. And all of the family members testified it was their intent and their belief that they lived in the same family household. Whether this court chooses to do an fact-intensive review or a broad brush analysis, the daughter-in-law, the son, and the granddaughter were all residents of the same household. Interesting in this case is the Farm Bureau wrote the automobile insurance policy, which is in question today. And the Farm Bureau also wrote the farm policy for the farm in question. They had the same agent who wrote both policies, and he always has written both policies. Part of the record on page 84, not highlighted by us in the brief, and I apologize, is the farm policy from Farm Bureau. And in that specific policy on page 84 of the record, Farm Bureau asks how many families are on that property. Number of families as listed as 1. There is no question that the policy has no definition of the word resident, has no definition of the word household, and as the courts have often said, these words have many shades of meanings. And when this court has addressed the same issue, they have called it a slippery word, an ambiguous word. And as this court has said, when there's a slippery word, it's not for the courts to sprinkle sand on the ice. What this court has done, and every court that's faced the same issue, is when there is an ambiguous word, the broadest construction, any reasonable construction, and the most inclusive definition should be applied to the facts in this case.
You're quoting the dissent now. Can you hear me, counsel? Thank you.
Again, sorry, Justice.
You're quoting from the dissent now in terms of looking at this broad construction, and you also raised in your early remarks that whether the court chooses to take a restrictive view or an expanded view, that either way we should include all of these family members as being in one household. Where would we draw the line, you would suggest, with all of these different kinds of configurations of family units that can be found on broad, wide stretches of land? Would you contend that this is a fact pattern that should be followed routinely, where you've got testimony from all the family members that live in separate households, arguably, or separate residences at least, on a tract of land, saying that they consider themselves to be a household? Is that dispositive in view of perhaps no contradictory testimony, or this these kind of cases to be decided on a case-by-case basis?
I personally think that it would be a mistake for this court to look at these cases on a case-by-case basis every time. I think that if we looked at an intensive fact review of this case, the facts are overwhelming that this was a family unit. But I think the court would be better served for purposes of future litigation over the exact same issues Farm Bureau is aware of to look at a broader view.
So are you suggesting that we hold at any time that we have a group of individuals who were related by blood or marriage on the same piece of farm-related property that's sufficient for them to be in a single household?
No, Your Honor. I think, quite frankly,
So what is the broader category you're asking us to hold categorically to be a household for purposes of this kind of policy?
Well, I think if the Supreme Court of North Carolina was going to draw a broad policy so they did not have to go through intensive fact review every time, the New Jersey Supreme Court in the Mozilla case came up with an excellent standard, which is doesn't need a common roof, but is it a harmonious relationship, a close personal relationship, close proximity, and a substantially integrated family. I think that that's a broad enough brush where there doesn't need to be, where's the mailbox, where's the driveway, all of those things get down into the nitty gritty, and one fact may be in one case, but may not be in another case. And
does that essentially mean that all families who own the same farm property and get along reasonably well and visit with each other are then a household?
I think that if you look at it from a standpoint of a substantially integrated family relationship.
What is a substantially integrated family relationship?
Well, I think that if you have a farm property and you have a bunch of members of the same family working that farm, open doors, all the bills paid by basically the same group of people, you have a substantial integrated family relationship. And as Mozilla said, it's a close enough personal relationship, it's harmonious enough to be one family. If the insurance companies find that it's too broad of a definition, they can approach and say, we're going to narrow our definition with actual words in our policy. But at this present time, when you have a family farm, which there are so many of them in North Carolina, when they are working the farm together, when they are working as one family together, our court has said that that is a broad definition look, and you look at it either intensively or you look at it from a broad brush. I think that we should draw a rule that is much more encompassing than what the present fact-intensive review is. As the court has said, we don't have to live under the same roof. That has long been the rule. You can be a resident of more than one household. Adults and minors can be residents of more than one household for insurance purposes. I think farm residences are different than a normal family home. When you have
Which cases are you talking about from our court, not the Court of Appeals, that have said that residents do not have to live under the same roof?
Well, all I can say to you is the expansive language in Jamestown versus Nationwide, which is the North Carolina Supreme Court that has addressed at least that part of the issue. I think that you look at the ambiguity issue, you look at the Wachovia case and the Great American case, which is looks to the intent of the parties. And so, yes, there is a lacking of a clear definition from this court, which is why I think the interest from the amicus on both sides to try to see if the farm issue as it relates to North Carolina, which is very prevalent, that we don't have to go through intensive fact-based litigation every time we face a farm issue.
Well, we often look to dictionaries to define undefined policy terms. And here, at least one dictionary defines residence as a group of people who occupy a single dwelling or dwell under the same roof. Why is that not a workable definition?
Because I think that it's asking for the court to give a restrictive definition to a word which is not defined in the policy. And I don't think, based on the fact that there are many courts that have said that resident and household are in fact ambiguous, that the Court of Appeals or this court should look to a simple dictionary. because if you look at the language in Davis versus Maryland, you can be a resident of more than one household, and there's no law contrary to that. And of course, we've all talked about the Court of Appeals case of Pascal, where the court found that in an intensive look at the facts of that particular farm, the families moved around from home to home, opened doors. But I think in this case, because Mrs. Martin was the source of virtually all of the income for all of the family members on this farm, that because they did in fact walk in and out of each other's house, they never paid rent. All of the bills in the second home were paid for by Mrs. Martin.
Well, they were paid for by the LLC, right?
Well, there was a mixture. When the LLC had money, it was paid by the LLC. And when the LLC didn't have enough money in the account, Mrs. Martin would pay it directly. But what's clear is that her son, David Martin, the daughter-in-law who was in the automobile accident, and her granddaughter who was in the automobile accident, received all of their money one way or the other from the income of the farm between June and September. And so this is a farm. This is an operating farm, and everyone operates and works on this farm together. I think it's significant that they share a driveway. I think it's significant that they don't have any rent. They don't pay any expenses. That anything that David Martin, the son, received for the benefit of his wife and daughter came from Mary. And I think that when you look at the interpretation structure of the case law, you can't give it a narrow definition when it is restrictive. This is
it's also pretty clear as well, though, that Ms. Martin, Mary Martin, was the only named insured on the policy. So while she took care of a lot of the financial aspects of the other family members, for whatever reason, she didn't see fit to have them on the motor vehicle insurance policy. What's your view of that in light of the other things you're saying?
Well, I think that if we look at the North Carolina statute 20-279.21, which is the motor vehicle liability policy defined, we have resident relatives as covered under those policies without the necessity of each and every family member being listed as a driver. They are resident relatives under the automobile policy definition under North Carolina statutes. And here, if the Farm Bureau, which wrote both policies, wanted to restrict it, they could have added restrictive language. If they wanted to eliminate the risk, they could have just simply said, same roof.
And just looking at it to note the fact that while you say that Mary Martin was so pervasive in terms of how she took care of the family members that also lived on the family farm, albeit in a different residence, that still she drew the line, at least in terms of this insurance policy, by naming herself as the sole insured. Is that something that we should just see as incongruous with her philosophy about the other family members, or should it have any indication for us at all?
Well, I think it's a fact. It's obviously a fact that David and his wife and granddaughter were not on that policy in any way, but I don't think it should be determinative by any stretch of the imagination, considering that all the bills, the taxes, the chores, the maintenance, virtually every other aspect of this family was integrated. They actually cooked the dinners at David Martin, the son's home, and brought the dinners over to grandma's house because it's just across the field. And so if ever there was an integrated family relationship, this is it. I think that when you look at farm families versus someone who has an extra house on their property and someone comes and stays at that house, but just is there for purposes of living, that's a different scenario. And I think that that's a scenario that this court can draw the line. But if you're working on the farm, you are integrated as a farming family, then you are one resident and one household. And I think to give the insurance company the benefit of the doubt by giving restrictive language, by picking out a single dictionary definition, I think that you're adding language and you're adding salt or sand to the ice. And so that has always been, I think, the insurance interpretation laws of North Carolina, that we don't do that. We don't offer that. And again,
Can you cite me a dictionary definition that's as broad as the definition you're proposing here?
I cannot. I think that you look at the case law that talks about residences, about the fact that it is a slippery word, that it's an ambiguous word, it's an undefined word, and then
Your colleague argues, if I'm understanding, Mr. Brock's got time to tell me I misunderstand his position, and he's told me that before, so I'll wait to be corrected if need be. But if I understood the argument in his brief, he said in essence, yes, household is an ambiguous word, but it's got to have some meaning. And what the rule that applies to ambiguous language in insurance policies would tend to say we ought to do is to take the broadest possible reasonable definition of the word and use that as the standard by which to evaluate the facts. Now, do you disagree with that as at least an analytical approach?
No, I do not. I, in fact, agree with that.
Okay.
And so the question becomes, what is a household?
Right.
And can you give a common meaning restrictive view of household that's undefined in the policy, or does household include appurtenances? Does it include the guest house next door? Many homes have guest houses. That's a household. Sometimes the children live in the guest house. And so the question is, where do we draw the line? And I think that when you're talking about the farm community that operates a farm, you have many people living in different parts of the property. And if they are family members, they are at least in the same residence as a part of the same household. And I think, quite frankly, that if the word was under the same roof was in the policy, then the Farm Bureau and other insurance companies that face this issue can say, look, we're only going to cover those people under the same roof. But I don't.
It seems to me, at least, that we've got sort of a two-pronged definition. First, they've got to be kin to each other. Secondly, it's got to be within the same household. Under the definition that you're prescribing, how is there a separate requirement that's associated with the necessity for the folks involved to be a household over and above the requirement that they be related? Is it just because of the integrated nature of the activity?
Well, I think the Court of Appeals, and I apologize, the Court of Appeals separated the words residence and household. And I don't think that the case law to the same degree has separated the two words.
Are you, and again, excuse me for interrupting, but are you saying in effect that there are not two different requirements here, just that there's just one?
Well, the first requirement is that they be kin.
Right.
The second requirement is they be residents of the same household. And what I don't think the case law supports is making it three requirements: family, kin, 2 residents, 3 household. I think residents of the same household is the ambiguous nature of the wording and the ambiguous nature of the case law. And I don't think the courts should be giving the insurance company the benefit of the doubt when there are a reasonable extension of that word, where you can say the most inclusive definition of residents of the household is the homes or buildings on that property where people are living that are also family members. And that's where I think the ambiguity lies, is in this phrase, residents of the same household. I think the Court of Appeals tried to restrict it by giving the definition of household from the dictionary by saying it must be under the same roof, and there is no case that supports that. And so North Carolina is not the only state that faces this farm issue, which is why the amicus brief went through the process of mentioning other courts, such as Idaho. Homes within the same curtilage fall under the definition of residents of the same household. And again, I'll refer back to the Mazzilli case from New Jersey, which is the integrated family, close proximity and close relationship. It has to be on the same property. And if it's not on the same property, they're not in the same household, they're not residents of the same household. And I think that's the difference. And I think that when you look at the specific facts of this case, if it's going to be a fact-intensive review, that the Martin family themselves did everything as a family on this farm. nothing virtually except for the car was paid for by David Martin, but he paid for that. He paid for his food. He paid for his clothes, but he only did it with money that came from the farm and his grandmother, Mary. And so if you try to compare it to what the dissent did, the facts in Paschal, you will see that the facts in this case are stronger than the facts in Paschal, I believe. And the court can easily extend it just on this case alone. But I leave it to the court to decide whether or not they want to go with a more expansive farm view. If I could, unless there's a question immediately, I would like to reserve my 10 minutes.
Well, you brought up Paschal. If I could jump in, what's your reaction on the applicability of Paschal as challenged by the other side, Farm Bureau, that Paschal involved the granddaughter at one time being in that residence physically, as opposed to in the present case where there's testimony that's uncontroverted that the family members that are at issue who in the accident never did live in Mary Martin's residential home?
Well, I think that the courts have said that you look at the living arrangements and the facts specific at the time of the incident. In Paschal, at the time that the litigation arose and the incident arose, in fact, the granddaughter did not live with the grandfather. The only evidence in that case was that when the father was in prison, she had to live with her grandfather, who provided most of the needs of the granddaughter. Well, I think the analogous facts are here is that Mrs. Martin always provided either through farm income or her own income from her own personal account, all of the money for all three of the other family members. And so I think that
is Paschal distinguishable, or are you saying it's in line with your position?
I think Paschal is in line with my position, and I think we have additional facts because at the time of this incident, Mrs. Martin still provided all of the income, all of the rent, all of the expenses, all of the supplies for the other house. And so I think that you take Paschal, and we have additional facts in this Martin case that Paschal didn't have. And I think that when you look at the way that the dissent addressed Paschal, you will see, one, our point, and two, we have additional facts. I think it's a mistake not to look at how Mrs. Martin's income provided everything for all three family members in the other residential structure. And that's a significant difference because she did it not just at the time, but she was the provider for all three of them at all times since the granddaughter was born.
The fact that the grandmother was away seeking medical treatment at the relevant time period, is that relevant at all?
No, I think that there is obviously you can be a resident of more than one household. Her son lived in the adjacent town where the Chesapeake Hospital was, where she was getting her cancer treatment. And so she had two homes. Everything that was provided to David Martin, his wife, and his granddaughter still came from Mrs. Martin. The fact that she temporarily was living with another son for cancer treatment does not change the facts at the farm itself. I don't think, Justice.
I have a.
Do you disagree? Do you disagree that David Martin was an employee of the farm?
I think David Martin has been an employee of the farm during the time.
Did he have a salary?
He got a $500 a week payment from his mother if the farm had money.
Was the daughter-in-law an employee of the farm?
She was also an employee when they had money during the time period that the farm was in operation, which is from June until September. So those are the only times.
Justice Davis pointed out, the farm was a separate entity from Mary, correct?
The farm was a separate entity for purposes of tax purposes only. She did not distinguish her checking account for purposes of payment of bills, payment of salaries, payment of expenses for either of the households. Yes, they tried to run things through the farm, but oftentimes the farm didn't have money, particularly after September until May. And so during October through May, Mary was the sole provider for all three of them.
Not in the record.
I have a quick. If you.
I'm sorry, Justice.
I have a quick follow-up from a question Justice Ervin asked a few minutes ago about the two prongs that there, you have to show kin and also member of the household. And as I understood your answer, and correct me if I'm wrong here, I understood you to say that if there's a farm and they're kin and it's on the same property, that's all the inquiry you need. Is that?
No, I think that it needs more than that. I think that that's too shallow and too narrow of a view. And that's why I've been trying to incorporate the close personal relationship, the integrated family working together on the farm. Because I can envision a large piece of property where there's a farm home that's being worked, and then their daughter, who has nothing to do with the farm work, just has living at a house down this mile away. I think that's a different circumstances than when someone, the matriarch of the family, pays 100% of the bills on a working farm for a farm family. And that's what we had here. And if you take the language of Pascal, which was, I think, even narrower facts than Martin, this is a working family farm, and everything was being run in some way or fashion by the matriarch. I'm going to reserve my 424 if I can. Walter, I think it's you, unless there's a question.
You certainly may, Mr. Bright. Mr. Brock?
Yes, thank you, Your Honor. This is it's a pleasure to represent North Carolina Farm Bureau in this case, along with my partner, Andrew Flint. And we're here to ask you to affirm the decision of the Court of Appeals in its conclusion that Gene and Marina were not insureds under Mary's policy. I think it's helpful sometimes to step back and see the forest and not be confused by the trees. The goal of this court and any court in applying an insurance policy or any other contract is to arrive at the intent of the parties. In this case, what is the intent of the parties? That's the issue before us. I submit to you, we need to reframe the issue as stated by Mr. Bright. It's not whether they were residents of Mary's household, although that is informative in the decision. What we're to do is to determine whether Mary intended for her son and his family to be insured under her automobile liability insurance policy. We have jumped into the definition of family member, but I submit what we do is we step back and apply the basic rules of construction established by this court. I guess it's now over 200 years, Chief Justice, that we're recently celebrating this court, but our court has.
But again, I'm going to get confused right off the beginning unless I ask this question, I guess. The policy language that we are construing does not contain the word intent, does it?
No, it does not.
I mean, what we're supposed to do is determine what was meant by the specific language of the policy, with intent perhaps being relevant to that determination.
Well, I would phrase it a little differently. Maybe this is what you were saying, Justice Ervin. But
what I mean, Lord knows what I was saying. Just tell me what the right answer is.
Well, what a contract is, it sets up the agreement of the parties. And so when we look at the contract, we're trying to ascertain, because there is a dispute, what was the intent of the parties. And so we look at the contract, we look at the terms of the contract to determine what that intent was. So maybe we're saying the same thing. But the one thing this court has done for 200 years, it has applied the plain meaning of the terms in a contract. It applies a common sense reading. And when the terms are not technical, then it's appropriate to look at dictionary definitions, because those are the commonly used definitions by people when they're trying to understand non-technical ordinary terms. And the courts also try to harmoniously construe all the terms together to make sense out of the agreement. And this court has repeatedly rejected what Mr. Bright is now asking you to do, and that is create legal fictions to substitute for the words of the policy or the words of a contract. Extraordinary. He has suggested that the court adopt a standard in New Jersey for what a household means. A harmonious relationship and a substantially integrated family. You will not find that in the insurance policy. That is a legal fiction that is not necessary to be used because we have the plain, ordinary words in this policy that are commonly defined in the dictionaries, and you will not find a dictionary that defines household as a substantially integrated family who has a harmonious relationship. The other thing this court doesn't do is this court doesn't rewrite the contract for the parties under the guise of construing it. So Justice Morgan hit on this point, and I'd like to continue reframing this. What was Mary's intent as can be ascertained from the written contract? What was her intent as to whether she wanted her son and his family to be insured under her policy? There is no ambiguity about what the policy shows.
If I can just jump in, I know you want to talk about intent, but I just want to make sure I understand your contentions with regard to the language of whether or not someone is a resident of the same household. And are there any facts other than the fact that they were not in the same structure or not under the same roof that you contend lead to the conclusion that they weren't part of the same household?
Yes, there are many, but I will start with the one thing that I think is most demonstrative of that. Mary didn't intend to insure them. She didn't, because at record page 54 and 55, she had the opportunity in her insurance policy to define anybody that she considered a member of her household as a named insured. So I would start there. You know, there are not many terms in an insurance policy, especially a standard policy required by statute such as this, where a party can affect what the terms are, but she could.
So are you now saying that the rule is that in order for someone to be considered a member of your household, that a resident of the same household, that you have to list them as a named insured?
I'm not saying that as a rule, Justice Earls. What I'm saying is if you're going to look at the intent of the parties, you have to look at everything in the agreement. And one of the most compelling things about the black and white terms of this agreement is that Mary did not designate her son and daughter-in-law as insured, and she could have listed their vehicles.
But the language of the policy says that they are insuring people who are relatives. That's one criteria. We know that's not at issue here. And people who are residents of the same household. And so if in just determining what that residents of the same household means, my question for you is on the facts of this case, is there anything other than the fact that they didn't live in the same house that you contend shows they weren't residents of the same household?
Well, sure. They have been described as dependent on Mary, but I would submit to you that all of the facts show that David and his wife, Jean, ran the farm. They generated the income from the farm. So frankly, I would, if it were under any other circumstance, I think David and Jean would suggest that calling them dependent on Mary is insulting. They ran the farm. They generated all the income. They did all the work.
Whether Mary was dependent on them or they were dependent on Mary, I'm just trying to get at what else would say they weren't residents of the same household other than the fact that they weren't under the same roof.
Well, that's a pretty compelling point, given the terms of the policy. They were not and never did. Even in Pascal, and I submit that Pascal's wrongly decided, went far beyond what this court has ever recognized as an appropriate inquiry on this issue. But even in Pascal, at some point in time, the young woman lived with her grandfather. They have never lived in the same home. They have never lived under the same roof. They've never lived in the same abode as Mary. That has never happened, nor vice versa. And so
I'm sorry, are there any circumstances under your argument in which individuals who've never lived under the same roof would still qualify as residents?
Never lived under the same. I don't know how you could get there. I mean, the whole point of the policy is one, you get to define who your insureds are, who the named insureds are, and then there would be others who have been residents of your household. I don't know how you could ever be resident of your household unless you actually live there.
So under your argument,
at some point in time,
if I understand your argument, you're really saying the analysis starts and stops there, that they never lived under the roof, under Mary's roof. Therefore, ipso facto, they cannot have been residents of the household. Is that correct?
I think that is correct. I'm just talking about the plain language of the policy, the plain English language and the definition of these non-technical terms.
I was going to ask if you thought Pascal was correctly decided, and I think you've answered that. Are you
I do not believe it.
Pascal?
I beg your pardon?
Are you asking us to overrule Pascal?
I think Pascal needs to be overruled because its analysis went way beyond the plain language of the policy. Before, this issue of resident had been looked at by this court several times, but when you looked at the issue of resident, you were always dealing with somebody who actually lived in the house at some point in time. And then the question was, okay, is the duration of time that they were staying at that house sufficient to make them a resident rather than just a visitor? Or if it were even longer than that, if they stayed there even longer, it could be that that became their domicile. But that was a period of time, a flexible, a gradation of time. Yes, Your Honor.
To follow up on Justice Davis's question, let's talk about, we've got cases that say in effect that a college student living in a dorm is still a resident of the family home. And you think those cases were wrongly decided?
No, I don't think so, Your Honor. Not if it was a temporary place, and I don't necessarily agree.
What about the situation? We've got a case that involved a child that had custody. One parent had custody, and the issue was the child a resident of the other parent's household, given that both the parents maintained separate residences.
Right, but the facts.
Was that one wrong?
No, sir, because the facts in that case show that she actually lived in both households, 3 days a week with dad, the other days of the week with mom. So
hypothetically, we've got a same situation, except that the child has gotten, one parent has primary custody. The only right the other parent has is visitation. Is that child a parent under your analysis of the visitation parent's residence?
I'm afraid I didn't follow all the questions.
Could you say, I doubt I can phrase it that badly again, but if you have a situation in which you have two parents, they're separated or divorced, one parent has complete custody, the other has nothing but visitation. Under your analysis, would the child be a resident of the household of the parent that only had visitation?
No, sir. She would not.
So it basically, in your view, this stops and starts with, at some relevant time, was there a period of time in which the person in question physically lived, had an abode in the person's, in the insured's house?
I submit that's not just my position. That's what the policy says. You can't reside somewhere if you don't go there and stay there. So yes, that is my position, Your Honor. You got to be there. And the policy is written the way it is. It could be written differently, but this is the policy we have.
So going back to Pascal, which obviously we're not bound by, but it does provide a useful comparison. The granddaughter had lived in the residence in Pascal. Why was that not enough?
Well, one of the things that concerns me about Pascal is, and even as Judge Inman pointed out in her dissent, is Pascal didn't even say that she had to be back and forth from between households during the relevant time of her accident. So if she was like the child who had parents who lived separate and apart, but she stayed with both of them off and on and during the time frame, because Newcomb has said you have to look at the time frame of the casualty to look at the residence issue. And so in Pascal, they talked about frankly, what a sad situation that young lady was in, with parents who weren't capable of really providing for her, and a grandfather who was obviously a generous soul and really looked after her. But I would just submit to you that Pascal is the classic example of hard facts make bad law. She was a very sympathetic situation. But they did not, in Pascal, follow this court's directive to look at the time frame in question. If, in fact, the record in that case shows that she was living with her father in one house and then going and living with her grandfather and back and forth during the time frame of this accident, then I think it would be like the child who had two parents living apart and basically shared custody, and the child went back and forth. We don't know that from the facts in the opinion in Pascal. So I submit to you, Pascal didn't follow this court's precedent by requiring the inquiry to go to the time frame of the casualty.
Well, you made it pretty. I'm sorry. You made it pretty clear about how you feel about Pascal in terms of overruling it. That's a Court of Appeals case. Davis is somewhat in line with that as well. But we've got our own precedent in this court in the Jamestown case as well as the Barker case. Are you wanting us to overrule those as well, or are those distinguishable, or how would this court statement in the present case otherwise line up with our own precedent?
I think our position here is absolutely consistent with the analyses laid down by the Supreme Court, because when the Supreme Court in all the reported cases has looked at residency, it has looked at a time frame. And Jamestown looked at that, and Newcomb looked at that. What was the period of time this person was actually staying in this other home? And they found it was long enough to qualify as a residence. And
Jamestown and Barker would still be in line with what you would say we should do in this case as far as your client is concerned, without causing any upheaval to our current case law?
Absolutely. If Marina had been staying in her grandmother's house frequently back and forth, and she stayed there during the time frame of this casualty, and she stayed there as many nights as she stayed with her parents in their own individual home, then I think this would be an entirely different case. But in this case, even in their own affidavits, they say, I lived in my house, she lived in her house. And so what my other problem with Pascal is that it created these legal fictions that this court doesn't allow to be imposed into a contract. It created this legal fiction of the most constant caregiver. I don't doubt that that's true. Her grandfather was a most generous and giving man. Nobody could read that record and not feel like this is a fine human being. Nobody could read that record without realizing that the young lady had been dealt a bad hand with her parents. They also created the fiction of the family farm, and that's not in any insurance policy either. And Mr. Bright would have us go even further than that. He would have us create a new legal doctrine called the family farm household, because he said so.
Well, let me ask you about that, because it seems to me that part of the issue is the rural versus urban context. And And your formulation that they can only be residents of the same household if they live under the same roof, would that lead you to conclude that if grandmother and the family were in a duplex side by side to each other, would they be under the same roof and therefore part of the same household if their finances were intertwined the same way and they received mail at each other's house and all the other, they had the keys to the doors and they went back and forth? Would the fact that they were in a duplex then mean they're part of the same household?
Not necessarily. I think it would require some further inquiry. The roof.
And so just one more question along those lines. In the urban setting, then it's not uncommon to have, or I've at least heard about people having homes with a grandmother unit where there's separate door to go in and out, but it's still part of the same house. It's still essentially, those folks all be part of the same household?
Probably so, depending upon whether they lived together. If she just happened to be physically next to them, but they didn't live together as one family, then no, they wouldn't be. They wouldn't be. I don't think this should be limited to just the rural area. Of course, we ride around, and this was, I think, alluded to by Justice Ervin, but you can see plenty of homes in rural North Carolina that are not farms, where they may have 2, 3, 4 acres of land, and they have multiple dwelling places on that property. And just because they may be family members doesn't mean they are members of the same household. Maybe I could be as generous as Mr. Thurman in the Pascal case, and I could buy all the houses on my cul-de-sac for all of my children and have them live in all those houses. Okay, does that mean they are members of my household? I fully paid for it. They didn't have to pay a thing. I think not. I think the question, I submit that we're making this too complicated. It is not as complicated as we are making it, because the policy says what the policy says, and that it requires them to be residents of the same household. And they were never residents in that household. And there's more than one abode. There's more than one home. There's more than one house. If the policy were written to include everybody on a family farm, it could be written to do that. But we're dealing with what we have. In the plain English interpretation of resident and the plain English interpretation of household don't go to the point where they create this legal fiction that Mr. Bright would have the court engraft on this policy, which is a new policy term, family farm household. Or he would have the court engraft on this policy a harmonious relationship with a substantially integrated family. The question, okay, what is the importance of proximity then? What if in this particular case, Mrs. Martin had her son in Virginia Beach was wholly dependent on her. She paid for his house. She provided for him completely. Was he then a member of her household? It's 20 miles away. This shows the dangerousness of the Pascal analysis of the most constant caregiver, which gets us into this whole issue of who is supporting who. I think that is a mistaken analysis. It doesn't follow this court's precedents. And I think we need to stick to this court's precedents and, importantly, stick to the policy. And the policy requires one to be a resident, and that is not a confusing term. The only thing the range is a time frame with resident, because all of this court's cases dealt with, did they live in that house long enough to become a resident? And I'll also add here, Mr. Bright suggested that their intent to be an integrated family or a family household is immaterial. What the courts have said is The statement of intent is a statement about how long do you intend to remain at this location. That determines whether you're a resident, that determines whether you're a visitor, that determines whether it's your abode. What you say after the fact about whether you considered ourselves a household is immaterial to an understanding of what the policy says and what the court should do with this case. So, you know, as Justice Morgan has said, I've let my feelings be known about the Paschal decision. You know, I don't know all the facts. On the facts, it could be correctly decided, but its analysis went way, way too far. And it's created this situation. I mean, we have all been sort of enticed into getting into all of this detailed analysis about the family farm income and you know, how much did Mr. Martin get paid? Did David Martin get paid? Or how much did Gene Martin get paid? How much did they work on the farm? You know, all of those issues. That's because of Paschal. That's because we had to develop those facts because of Paschal. And I submit to you, we need to get back to what the Supreme Court has said is the proper inquiry and stick to the policy and the plain language of the policy and stop engrafting these legal fictions on these contracts of insurance. The Paschal Court did exactly what Judge Inman accused the majority in this case below doing, and that is lawmaking. I submit to you, Paschal went into lawmaking and got beyond error correcting. But all that said, and my feelings about Paschal aside, I'll submit to you that even if you were to apply a Paschal-like analysis, we should win in this case. And I'd like to show you what we've just outlined. What are the undisputed facts in this case? And these are undisputed. The date of the accident was January 6, 2014. Okay, so according to Newcomb, we have to look at that time frame to determine whether someone was a resident of the household. Well, we don't really have to look at that time frame as terms of whether they ever stayed there, because they didn't stay there. They didn't live there ever. But what it is relevant that on January 6, 2014, a couple of things. First of all, as the testimony shows, in the wintertime, Mary Martin didn't even come down except on occasion to the island because, as she said, I don't like to turn on the heat in the house and it gets too cold. So Knott's Island is a very unique place, but she didn't come there in the wintertime on a regular basis. So this integrated close family relationship couldn't really happen in that situation because she wasn't there. We're not saying that that wasn't a residence of hers. It was, she wasn't living there for this close relationship to exist. So also at the time of the accident and for a year before and nearly a couple of years afterwards, she was staying with her son in Virginia Beach because she had cancer and then she had knee replacement. So she wasn't even there much at all for about a 3-year period of time. Other facts, if you could go up, Andrew. And I look at this, it's surprisingly totally different from Mr. Bright in terms of the wages and the payments. David and Jean were employees and David managed Martin Farm. They created an LLC. That limited liability company paid from its business checking account David's salary and Jean's wages. David's health insurance until they dropped it. All of the auto insurance, which makes sense because all the autos were used for running the farm. The power bill for David and Jean's house, that was a non-wage compensation for them because they didn't get paid very much and they worked themselves to death on the farm, as is clear from the record. She paid the property taxes for the entire farm, which makes sense. She provided for the appliances for the David and Jean's house, which makes sense because she owned the house and she was providing the house to the farm manager. It could have been somebody who was unrelated, but it happened to be her son, David. She paid for repairs to her house. She supplied the landline, and as they explained, that was used for the farm business. She paid for David, Jean, and Marina's cell phones. As she explained in the depositions, the cell phones were used for the farm business. Paid for the post office boxes. They were used for the farm business. They had a business account at Knott's Island Market for the business. If you could scroll down, please. Okay. According to the evidence, all business checking account payments were deducted as business expenses on the company's tax returns. And then, as we talked about, David, Jean, and Marina never lived in her house, and David and Jean fully supported Marina, unlike the situation in Pasco. David and Jean paid for their own and Marina's personal expenses, including groceries, clothes, medical treatment, medicine, David and Jean's life insurance, cable. Whereas in the Pasco case, all of that was paid for by the grandfather because, you know, apparently the father was a ne'er-do-well and the mother was non-existent. She was not present.
Thank you, Mr. Brock. Your time is up.
Thank you, Your Honor.
Thank you. Mr. Bright, rebuttal.
Mr. Bright, you're on mute. Please unmute yourself.
Thank you. I'd like to go back to one of the questions from Justice Earls when it had to deal with the duplex and Mr. Brock's answer to that question. His answer was, it depends on whether they live together as one family. That was the point made by Mr. Brock that would distinguish a duplex in an urban setting. In this case, there is no question. Every affidavit and all of the depositions are that the family did in fact live together as one family. They intended to live in one family, and they always thought that they lived on one farm. And it's interesting that the Farm Bureau would try to pretend that the original farm policy that covered all of the acreage, all 76 acres, had the question, as I pointed out on page 84 of the record, the number of families living on this property is one family. And so when Mr. Brock talks about legal fiction, Mr. Brock is asking this court to provide language for the farm policy that says it needs to be one roof. And that just simply isn't in the language and isn't in the case law. If they wanted it, if they wanted to define it, the insurance company which wrote this policy had the ability and the right to change it, but they never did. And they never did it even after Pascal, which was the law in the state of North Carolina at the time that this policy was written. They chose not to change it. There was also another question.
Mr. Bright, what if you had a 5-acre farm, okay? Let's say you had 2 dwellings, one on one end of the farmland, one on the other, and there was some interaction between the residents. There were family members. They did go back and forth, but they maintained separate dwellings. Would your argument be any different?
I think, and I was about to address that point with regard to the earlier question when Mr. Brock said, could the son in Virginia Beach be considered a resident? And I think that the curtilage piece is an important one. Is it on the same property? And is there an interwoven family relationship? And so I think when the farm property and someone lives on a home on the farm property that is not necessarily an integral part of the farm relationship, I don't believe that we can expand, or probably would not expand, the language to include every family member that happened to live in a piece of a building on a farm just because it was on the farm. The question I really do think is, were they living together as one family, as Mr. Brock said? And of course, the language that I cited to you from the New Jersey Supreme Court. is this a farm property where they're operating the farm as one family like the Martins were doing? Or is it just a home sitting on the property that has nothing really to do with the farm operation? And I think that's a distinction that's a very important one. Having a home on the property just inside the curtilage doesn't necessarily mean that it's an operating farm for the intent of having one family. And I think if you asked many North Carolina families who said, oh yeah, I live on the property, but I live in my own place, that's a different answer than I live in my own place, but I operate the farm with my family in the main abode. And I think what Farm Bureau is trying to do is to conflate the language of domicile with residency. And they're asking this court to include into their contract language the one roof rule, the same roof rule, which should not be done when you have, by definition, by this court, an ambiguous word. You know, the Court of Appeals calls it ambiguous, cites all the right cases talking about ambiguity, and then says there's a plain meaning of the word. And I don't think you can have it both ways, which is why the dissent was so vigorous in saying you can't do that when the word itself is ambiguous and there has multiple meanings. It needs a broad definition, all inclusive.
Thank you, Mr. Bright.
Thank you all very much. I enjoyed this.
Thank you, Mr. Bright and Mr. Brock and Mr. Flint.
Thank you much.
Madam Clerk, would you recess us?
Yes. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court. Thank you all. Have a good afternoon.